I'll be honest with you, Liz, the case that I personally am most excited about is actually a huge First Amendment case. It's actually right here in the D.C. area in Bladensburg, Maryland. It's the so-called Peace Cross case. Now, this case involves a 40-foot-high cross memorial that was built in 1925, shortly after the end of World War I, to honor 49 Americans who paid the ultimate price, dying in Europe to secure our freedoms. Now, a radical atheist group has sued this cross on alleged First Amendment grounds. Full disclosure, in addition to my role with the Daily Wire, I actually am also of counsel with the religious liberty law firm, the First Liberty Institute, that brought this case, so I have some interest here as well. But they sued here basically alleging that this is a violation of the Establishment Clause of the First Amendment. The Establishment Clause prohibits Congress from making any law respecting an establishment of religion. In my opinion, Liz, it is up there with the Cruel and Unusual Punishments Clause of the Eighth Amendment as the two most wildly misinterpreted and misconstrued provisions in the entire Bill of Rights. And I think that this is the court's best chance since at least the 2014 case of Greece v. Town of Galloway, and potentially a lot more than that, to do some serious doctrinal work in paring back so much rotten, misbegotten case law and getting us back to where something like this shouldn't even be sued. It is a war memorial to honor the dead.
Right, so here's my question, and maybe this is an elementary question, but if we're talking about the Establishment Clause, it says that, you know, Congress can make no law regarding the establishment of religion or prohibiting the free exercise thereof, and roughly it says that. What on earth does a cross in a cemetery have to do with government forcing citizens to participate in religion or prohibiting the exercise of religion?
Yeah, so it doesn't, is the obvious answer here. Now, part of the reason why the Establishment Clause has been so grossly misconstrued by black-robed oracles going back at least 60, 70 years, and perhaps more than that, is twofold. One is, any person who can read the text of the First Amendment understands that the term separation of church and state is not in there. It actually first appeared in a letter that Thomas Jefferson wrote to the Danbury, Connecticut Baptist Association in 1802, I believe was the year. And the Supreme Court didn't adopt it into their case law until a 1947 case called Everson v. Board of Education. So this notion of separation of church and state, which has become part of our Establishment Clause case law, has nothing whatsoever to do with the actual establishment of religion. But more generally, the Supreme Court has made incredibly lax and loose the rules of what lawyers call standing, which is your ability to just bring this lawsuit in the first place. And it is comical that they have allowed essentially an aggrieved, offended radical atheist to just bring this suit. Because there's no injury. As you properly know, Liz, there is no actual injury to an offended observer. You know, as my boss at the Daily Wire would say, facts don't care about your feelings. If your feelings are hurt, that doesn't mean you have a First Amendment claim. So that is what I'm most excited about, to see if this allegedly conservative majority with Kavanaugh and Roberts starts paring that back a little bit.